All right, ladies and gentlemen, I think we're ready to get started. I plan to just go down the calendar, the order that it's in. Uh, Chairman Strickland's running a little late on his bill, and it'll probably go longer than the others anyway. So I want to go ahead and do his on the end. So with that, I'll start with Senator Brass on Senate Bill 32. If you want to come right up here in front of the pole. We call that the hot seat. If you would like to introduce yourself and then tell us about your bill.
Sure. Thank you, Chairman. Members of the committee, Senator Brass, District 28 down in Noonan, Georgia. Actually, fairly close to the airport. I can drive to the airport. I can get door to door in about 25, 30 minutes. And which is, I say that for a reason. Because of our location to the airport, we actually have a lot of federal employees in Coweta County and in the 28th district. So what SB 32 does, and you do have a sub, but we had a late arriving sub.
Let's mention that number.
That's LC 364783 Sierra.
Thank you.
So let me talk about Section 2 first, because that was the original bill and that was what we sent over from the Senate. Current law allows all government employees, state, county, or city employees to be exempt from public record unless a public disclosure is required. Things such as home telephone number, mobile number, home address, things like that. And again, with me having lots of federal employees, I had one go down to the county, and there's a process you have to actually go down and apply for this. And this federal employee, and he's an agent of I don't know, let's call it FBI, but he's an investigative agent, and so you can probably understand why he wouldn't want his home address out there, and for various reasons. So he goes down to the county, he applies to be removed from the public records, and the state law actually prevents him from doing that because we did not include federal employees in our law when this was originally written. So again, current law is state employees, county employees, city employees. All we're doing is adding federal employees. So that's Section 2. That's what SB 32 was in its original form. Now, getting into Section 1, and this came from Representative Gullett. It was a bill he had been working on with the Secretary of State's office, and they just got him really the language too late. And my understanding of it is, and I'll do the best I can to describe it because I just learned of this yesterday, but and he's here if we need further detail, but essentially there's an issue in the Secretary of State's office if you go and you try to look up, say, a licensed nurse or a licensed builder or whatever, you can actually find their home address through the Secretary of State's website. And one of the reasons is because if you look there on lines 11 through 13, it basically lists all the things that are, I guess, that won't be shown, and what's not there is home addresses. And so it's really just kind of a little fix, and really just to me a little glitch in the law that causes a glitch in the system. And so we're just trying to tidy that up. That's the best I understand that section.
All right. Thank you, Senator. Anyone have any questions for the Senator? We have. Yes, Chairman.
Is there any federal law that protects federal employees that this might be in conflict with?
The only thing that I'm aware of would be if there's a federal disclosure and or like a financial disclosure, or there is. Yeah, so I was a federal employee once, worked for Congressman Westmoreland, and in that role, I had to file a financial disclosure every year, and those types of things would not be exempt. Simply what it is more about my home address. I could have had my home address removed. I could have had all that removed. And if you think like you can go into Q Public of any county and I can look at a property, I can look at a property owner, and I could find where you live pretty easily with a simple search. And again, this is just those types of things. It's removing that from that.
So there's no federal statute that
Not that
absolutely
I'm
protects
aware of.
employees that's like the state one. There's no reason to think we're in conflict in any way.
No, ma'am. And that's, I mean, Ledge Council to me does a fairly good job of
they
making
do,
sure
yeah.
keeping
Thank you.
us out of those types of situations.
Thank you.
Do we have any other questions? I don't see any. Now would be that time. Have a motion and a second. Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right,
Thank you, Mr. Chairman.
your bill's out.
Where do I go next, Mr. Chairman?
Let's see, we got the full committee. and
Full committee haven't scheduled it.
Okay.
Have been scheduled. so
Y'all, but the chairman will look.
We'll let you know.
Great. Thank you so much.
Yes, sir. All right, Senate Bill 34. All right. Senator Dixon, how are you, sir?
Doing good, Mr. Chairman. How are you doing?
I'm doing great. All right. You want to tell us about your bill?
Absolutely. My name's Clint Dixon. I'm senator from the 45th, which is the northern third of Gwinnett County. I'm a freshman, so I always like to refer to Renee Unterman, my predecessor. But yes, here, and thank you, Mr. Chairman and board members, committee members for hearing Senate Bill 34. Senate Bill 34, what it is, it's the First Lady's bill, and this bill allows for victims of human trafficking to petition the court for a name change under seal. It also allows the court to waive the requirement to where you have to run notice in the paper, I think up to 4 weeks. And then it also later on would give the courts the power to unseal the petition later on if they see fit. And it's a very important piece of legislation for victims of human trafficking. These human trafficking rings, they are large networks, and when a victim's rescued, and if some of the perpetrators are arrested, typically they don't take down the whole gang. And I know some victims in my district that this legislation would have meant a lot to them, being able to change their name because they were in fear of retribution from these different individuals.
Yeah, this isn't a new thing in our code. We've already got it for victims of domestic violence.
Yes, sir.
Where they can make name changes. Does the committee have any questions? I'm not seeing nothing online. All right. I have a motion. Do I have a second? Have a second. Any further discussion? All those in favor signify by saying aye.
Aye.
All opposed? All right. Your bill passes to the full committee.
Thank you very
We'll
much.
let you know when we have it up for a full hearing.
Thank you all.
Thank you. All right. And Chairman Strickland informed me that he's going to be held up. He's in another meeting, another committee. And I told him that we would stand at ease until he gets here.
So we're going to get started, and Chairman Strickland,
Are they on?
you need to kind of reintroduce, like say, and we're going to get started.
Okay. All right, ladies and gentlemen, I think we're going to start the meeting back up. Chairman Strickland, I think, is going to be a little while. So while we're waiting on him, we can go ahead and maybe get some of the testimony out of the way. So I think that'd be a smart way to go. So this is Senate Bill 163. The LC number I have is 413012S. And it has a, oh, okay, anyway, that's it. So basically this is the speedy trial, statutory speedy trial bill. And this basically applies to the state courts and the superior courts. And if I'm going to refer to it, I'm probably going to refer more to the superior courts than I am the state courts, but they kind of mirror each other. I didn't see really any real difference between the two. So this basically has to do with the COVID situation. And the chief judge of the circuit will be looking at certain criteria and deciding whether they want to declare an emergency order that follows the superior court, or I'm sorry, the Supreme Court's judicial emergency order in order to handle the trial work that's coming through those courts. It sets out the criteria or factors to be looked at by the judge in determining that they want to grant an order, and then sets out I guess the way the judge is going to declare the order, and then it has a time period. And I think that's probably the part that's going to be most controversial. It says that the total period of relief granted under this subsection shall not exceed twice the total duration of the preceding judicial emergency. And I've had some question about what they define as a judicial emergency. Is it the total time? It says the total period here, but are we talking about the last order, or are we talking about the whole series of orders that have been issued by the Supreme Court to grant relief in the lower courts? And then on lines 139 and 40 is where they have the sunset provision on June 30th, 2023. So I think those are the areas that we're going to get the most questions about. But I'm sure there's other stuff in here that people have been looking at, that I've been looking at as well, where I might have a question or two. I think at this point, what I'd like to do is call in folks from the Judicial Council, Tracy Mason, Darren Enns, for their testimony. Yeah, come on up. All right, Ms. Mason, if you want to introduce yourself and who you work for, and
Absolutely.
you want to talk about the bill.
Okay. Well, good afternoon, Mr. Chairman and members of the committee. My name is Tracy Mason. I'm with the Judicial Council of Georgia, Administrative Office of the Courts. With me today is Darren Enns, Policy Counsel with the Judicial Council of Georgia, and he primarily work on the drafting of this bill. So he's here to answer any questions, walk through the bill, and speak to the specifics. We also have Chief Judge Brian Amaro from the Flint Judicial Circuit and President of the Council of Superior Court Judges, and Chief Judge Chris Brasher from the Atlanta Judicial Circuit. So thank you for your consideration of the bill today. I will be brief, but the Senate Bill 163 is the #1 legislative priority for the Judicial Council during this session. It is urgent and time sensitive, given the state of emergency that we are currently in, the public health emergency and the corresponding judicial emergency. And it's a critically important bill to ensure the continued functioning of the court system after the emergency. This bill was drafted, vetted, shared with many stakeholders, including the Prosecuting Attorneys Council, the Georgia Public Defender Council, the Georgia Association of Criminal Defense Lawyers. We spent time talking through the bill, hearing input, and taking some of those feedback and suggestions and working them into the bill as filed. So again, thank you for your consideration today. I don't want to take up too much time, so we're happy to walk through the bill, answer questions, and again, the judges are available to speak to the situation and the issue in the courts as we move through this emergency.
All right, Mr.
Very
Enns, if
good.
you want to walk us through the bill.
Sure. Good afternoon. My name is Darren Entz, Policy Counsel, the Judicial Council, Administrative Office of the Courts. And I did work with many of our Supreme Court justices and judges and other stakeholders to draft this bill. We've made a lot of changes over time. We've tried to account for a lot of different scenarios. And so I'll go ahead and walk through it at a high level for you. Beginning on line 14, we have here, except for as provided in 38.362. This is the section here related to a current judicial emergency. Just putting on the reader on notice here that there's another procedure that they need to look out for. To be clear, this is not during a judicial emergency. This is following a judicial emergency. What we are proposing here. To deal with really the aftermath of a judicial emergency. As under current law, a judicial emergency, there's basically two general types, and those are laid out in 38.361 there on at the top of page 2. We have kind of a general judicial emergency, which can last basically up to 90 days. And we also have a public health emergency version, which can last basically indefinitely, so long as the governor has declared a public health emergency. Those public health judicial emergencies are going to be in 30-day increments, and we've seen that our Chief Justice has been doing that every 30 days during the judicial emergency. Moving on to section 2 on line 27, we're designating the existing text of 38.362 as A, because we're adding a new section B, which would really contains the main parts of what we're proposing. As you can see however, under A, what it would be designated A, in a current judicial emergency, the Chief Justice is authorized to suspend, toll, extend, or otherwise grant relief from deadlines and other time schedules of filing requirements. And number 3, as you can see, 3 is the time for which to try a case for which a speedy trial demand has been filed. See, so once the judicial emergency ends, because the governor's public health emergency has ended, the Chief Justice will no longer have that authority. So that's basically why we've proposed this statute, because following the judicial emergency, there's going to be a huge backlog of cases that we'll need to address, and the statutory speedy trial requirements currently located in Code Section 17.7.170 and 17.7.171 will need to be there need to be some relief granted there so that we can manage the backlog in an orderly manner, so that the judicial branch will able to maintain an orderly system of justice. Moving on to the main parts of the bill, on line 47, we have what is B1. We're using the definition statutory speedy trial requirements, which incorporates those in 17.7.170 and 17.7.171. 70 is going to cover your non-capital offenses. 171 is going to cover your capital offenses. Basically, under 17.7.171, a case in a non-capital case, it must be tried when demanded or the next term, or else the defendant will be discharged and acquitted. Under 17.7.171, capital cases, they must be tried within 2 terms after the term which the demand is filed. So that really illustrates the importance of our proposal, in that the effect of the judicial system to address statutory speedy trial demands that are filed en masse after the judicial emergency ends would be the discharge and acquittal of many defendants, without any chance for victims to be heard, without any chance for the public to try the case. And so we're trying to to really have a balanced approach here where we can account for not only the rights of the defendants, but also the rights of the public and the victims. In 2A, we really start on line 50. This is where it establishes a chief judge, either of a superior court or a chief judge of a state court, is granted the authority to suspend, toll, extend, modify, or otherwise grant relief from the statutory speedy trial requirements that are defined in B1. And this is again following a judicial emergency. And it is if compliance with such requirements is impracticable based on the factors that we're going to require in the next section. So under B, relief is authorized if a chief judge certifies, and there's an accountability requirement there. Chief judge certifies that under the totality of the circumstances, and these are important words, arising from the judicial emergency. This is not just any time. These factors, these circumstances must arise from the preceding judicial emergency. So anyone who says to the contrary is incorrect. It's a misstatement. This is only available in circumstances arising from the preceding judicial emergency. And those circumstances cause compliance with the statutory speedy trial requirement to be impracticable. And we laid out some factors in there. In Roman numerals 1 through 8 there, which we've tried to lay out some objective criteria. 1 and 2 here, factors are state collected data. We've based that on our caseload reporting data. 3 and 4 are going to be more locally held data. The number of speedy trial demands is going to be really a court by court issue, as well as a number of jury trials that were held.
Before you move from there.
Yes, sir.
Why wouldn't you have the judge consider all of these factors?
Well, we certainly agree that they should all be considered. However, not all of them would be applicable to all circumstances.
Right, but still in their order, they could include the ones that do apply.
Certainly, yes.
And either state that the others
Right.
don't or whatever,
Right.
but
That's absolutely how we envision the process
Okay.
to operate. Yes,
thank you.
certainly. And so we have in 5, Roman numeral 5, ongoing space limitations or health and safety concerns. And those are really, I mean, we have courts across our state that have a wide variety of resources. You're going to have the large county courts. You're going to have, several courtrooms. You're going to have a wide variety of facilities that are available. So we've tried to accommodate ongoing space limitations there. Limited availability of judges, courtroom personnel, prosecutors, defenders, and some of the most important on this list are really the expert witnesses, the forensic analysis. There's a limited number of people that can do forensic analysis, as well as you can say other relevant persons would include probably a court reporter would be. There's a limited number of those people. So it's not just the limited availability of judges that can really throttle the amount of jury trials that you can have. It's a whole system, a whole ecosystem of people that you would have a limited availability of.
Mr. Enns, I'm sure you would agree that there's a limited number of judges and other personnel currently.
Oh, certainly,
Yeah.
yes, certainly. We do the best we can with what we have.
Yeah.
The next, number 7, the extent of efforts made by prosecuting attorneys and the court to reduce the number of criminal defendants held in custody awaiting trial. This particular item was we put this here at the request of GACTO. So that is one of their requests that we accommodated. 7, Roman numeral 7, on line 74 and 75. Line 76 and 77, Roman numerals 8, other relevant facts. We envisioned that because we have such a diverse judiciary across the state, there might be facts that we just haven't contemplated here. There may be something that we haven't thought of. And so that was the basis of the other relevant factors there. All right, so that rounds out the factors. Any other questions about the factors?
Well, the number 8
Yes, sir.
is a little bit of a concern
Yes,
in that it really kind of opens it up to anything.
yes.
But
Even then, the fact would have to relate back and be part of the circumstances arising from the preceding judicial emergency. So there's still that tie-in, that it's not just any old factor. It's not the normal business as usual or stacked to the gills with people all the time. It's all of these factors have to be the totality of the circumstances arising from the preceding judicial emergency. So it still has to relate back to that. So that would be my response to that question. So moving on, line 78, an order granting a relief would be accompanied by a certification. This is the certification that we've been talking about, that if a judge is going to request this authority, they're going to need to certify and put themselves out there in writing the facts on the ground and what's going on, so that the public knows that they're doing this and why they're doing it. And as well, so that there's an accountability function, not only from the public, but also from the Chief Justice, which we'll see later has a check on this authority.
All right, hang on just a second.
Sure.
Representative Oliver, you have a question?
Yes, ma'am.
Thank you, sir. It's helpful that I understand now that this only is the aftermath from the preceding judicial emergency.
Yes, ma'am.
And you helped me by that there were two different kinds of, now as a practical matter, we're talking about the public health emergency right now.
That's right.
But in the last several years, have there been other judicial emergencies established in any of the 46 circuits? I'm trying to figure out how often that happens.
Hurricane would have been one.
Was there
Yeah, we could certainly research that.
I don't believe that there has been any statewide. I do believe that there have, and the judges may be able to speak to this better. I do think that locally, I think there may have been some courts in South Georgia after the hurricanes and in those types of situations.
But they could be the other
limited.
kinds of public health could be statewide or it could be local, I guess. But the others, I assume, would be all local, would be practically all local.
I think the current statute provides that the Chief Justice can declare a statewide judicial emergency in the non-public health.
Yes, but
Correct.
it would need to be limited.
And
its
I'm just
duration.
curious, and somebody I'm sure can find that out. How often has that been exercised
research
by a
that.
local judicial circuit?
We can get that for
Certainly,
you.
we can research that.
Another idea that was brought up was cyber attacks as well.
Yes,
Correct.
certainly. And
Well, courthouse burning down, records burning down. I
Records,
don't,
certainly.
yeah.
yeah, floods, fires, hurricanes, you name it.
Mhm.
It could be,
Cyber
an
attack
issue.
and hurricane, I know, are the ones that come to mind
Yeah.
locally
Mhm.
over the past few years.
certainly.
but I don't think they've done it in the last 4 years. That's what I'm asking specifically. I know those are appropriate opportunities, but I'm just curious what the number has been actually.
Sure.
And my guess would be that the local jurisdiction or the chief judge in that circuit probably declared it. I don't know if it was widely known,
Yes.
but I would say by order of that judge that they handled it that way.
And I assume there's been no litigation or no case law on any of that historically in Georgia. Local circuits declaring emergencies and that being contested anyway. No case law.
No, I don't believe
don't
so.
think so.
Judges, I don't know.
We would have to look that up, and they'd probably be shorter in duration than what we're contemplating here.
Thank you, sir.
All right.
So moving on with the details of the certification, which are important because the judge is going to be certifying all of these things and putting themselves out there on the public record to say why they're doing what they're doing. And either the chief judge that actually orders individually the relief to be granted can certify, or there's a function in here where the majority of Superior Court judges or a majority of a state court judges can request relief from the chief judge. And if they do so, the chief judge must grant that relief. And so we thought that, having a judge, the chief judge, who it wasn't his idea, the majority requested it, having them do the certification might not be such a good idea. So the judge could use the majority's certification. So if a majority is requesting this, the majority is required to come up with the certification, the
Okay.
reasons that they're requesting it.
Okay, let me
And-
stop you right there.
Sure, sure.
I want to recognize Chairman Strickland has now joined us, and well, if you want to come up to the microphone and anytime you want to
Thank
speak
you.
to it, you're
Good
welcome to
afternoon,
do
sir.
that. All right, now,
Certainly. So we can either have the individual chief judge who's ordering it or the majority of the judges who are requesting it certify, but either way, a certification has to be produced. The certification, what is actually required in it starts on line 89. Each certification shall include the following, and you're going to need to include supporting statistical data and findings of fact. And so we've talked about the factors that are above, so you need to include the things that would be relevant to you out of those factors there. Also in 4B, we have another suggestion from Gactyl that we've incorporated here. A plan must be part of the certification. And that plan needs to be how you're going to resolve the cases in which the statutory speedy trial demand has been filed as expeditiously as possible. The plan also needs to have an order of priority where the cases that are called are prioritized based on defendants who've been in custody the longest. And so those people have been in custody a long time are gonna be prioritized within that plan. And finally, the plan needs to also state the number of trial weeks scheduled for each judge. And so that's gonna put also another spotlight on whether that particular court is doing the best they can as far as trying to resolve the backlog. All this is going to have to be on public record. So moving along, that's the certification portion. In 5, starting on 99, we have basically the authority granted to a chief judge of a superior court judicial circuit. We have acting independently of emergency declared by the governor, because that's really the whole point of this, that we're hindered by the fact that the current judicial emergency statute requires an emergency declaration by the governor. So once that ends, we're kind of out of luck. And so that's the point of that. May grant relief from statutory speedy trial requirements. Also, that's the point, but particularly for a county in his or her judicial circuit. So Superior Court judges have statewide jurisdiction, but we're trying to narrow it down here to a county by county determination within the judicial circuit. We're trying to keep it as targeted as possible because every county has different circumstances. So it's a county determination here, county by county determination. The chief judge will act in their own discretion, and they shall act, as I was alluding to before, the majority provision, they shall act at the request of majority of the active Superior Court judges in their circuit. So that's basically their authority. Again, 6 is the embodiment of the majority provision. The chief judge must act if requested by a majority. From lines 111 through 120, we really have corresponding provisions for a chief judge of a state court. So they just kind of mirror one another there. They have, the same provisions there, except for it's going to be the active state court judges in a county that are going to be in the majority voting in favor of a relief there. In starting 117, we have, moving on, we've already passed that. Line 121, these are limits on the relief. So each period of relief shall not exceed 8 months. So that's the maximum. And the reason we picked 8 months is because that's the longest term of court we could find in the state. Terms of court vary across the state wildly. And on the next page, line 123, the relief must end on the last day of a term of court. And we did that because we want this to align with terms of court. And so it functionally works best that way. And on line 124, the total period of relief granted under this subsection shall not exceed twice the total duration of the preceding judicial emergency. This was our attempt at a operational sunset based on what we consider objective criteria, because really what we estimate is that digging yourself out of the judicial emergency will probably take at least twice as long as the judicial emergency lasted. And what we're envisioning here is the total duration of the preceding judicial emergency. So that's all of them stacked together because we had to go in 30-month increments. So, I mean, 30-day increments. So, I mean, if we did it only by one judicial emergency, it's going to be 30 days, 30 days, 30 days. 30. So we had to really add them all together to get a total amount.
So when
And-
it says total period and total duration, it's talking about the whole series of,
Yes.
not just the 30-day order, but it was
Right.
prior to that.
Since the first declaration of judicial emergency to the end, to the last. So all taken together. So, and you could hear from some of our judges who've actually been talking about this with their respective courts. They can let you know how long they think it's going to take them to dig out of this. And I think that twice the judicial emergency is might not even be long enough for that. But this is,
All right.
we'll
So-
see. It depends on the volume we have.
While we're on this subject,
Yes.
then can you jump down to 139 and 140 and talk about the drop dead date that we have in here?
Right, yes, and we added that. We did not have that in our original proposal. We added that again as a concession to, I know Gackel wanted us to put that in there from the
How do the
beginning.
two work together then?
Well, because they're two different things. I mean, effectively, if we don't know how long the judicial emergency is going to last, these are unknown times in the future that we're talking about here. And so we really don't know how long that's going to last. It might be longer than June 30, 2023 that we need to dig out of this. It's possible. So, I mean, it might be fairly certain that we might have to be back here and asking for an extension. But I mean, at least it gives us a time that we can kind of plan for. So I guess that could be something that.
Okay, so let's just say everything comes to an end
Mhm.
on the judicial emergency side. And that is, let's just say June 29th.
Mhm.
And the judges across the state declare their emergency under
Mhm,
this
mhm.
bill. And that would be nearly a 4-year period, thereabouts, maybe less. You see where I'm going with that?
Certainly.
Is that what we're saying? Is that this would extend out from the chief judge's, Superior Court judge's order? It would extend out another possible 4 years?
No, I don't think that the any order that's in place that would be in place prior to that date. The maximum order is a length of 8 months.
Of 8 months?
Yes.
Okay,
So any order would die after 8 months.
okay.
Yes.
And just,
But I'm still under paragraph 10 up there. Shall not exceed twice. Okay, it's just shall not exceed twice.
Yes. It could be shorter than that. It's just
Okay, but
that's the max.
The maximum length then is 8
Mhm.
months,
Right.
is
And
what
if
you're saying.
the maximum order length, each order can be a maximum of 8 months in duration.
So you have to recertify again after 8
Yeah.
months. Right.
Every 8 months, you're
So
coming back.
let's go back to my example of June 29th. The order comes out, 8 months go by, the judge can declare another one,
Yeah, but you have to come up with a separate certification.
but the
Not
Ju-
after that 2023 date.
No,
Yeah,
that
June-
after that date, this statute goes away.
That's a hard deadline, that sunset.
okay, all right, that's what I'm trying to clear up.
Right.
Okay, thank you. Hang on, I got Chairman Oliver over here, go ahead.
I'm kind of in the practicality in the weeds too, so forgive me. I'm following up with Chair Gunter. As a practical matter, we are under a statewide emergency right now.
Yes.
And yesterday, correct me if I'm wrong, Justice Melton said we can proceed with jury trials. So right now, under the existing order, defendants filed speedy trial motions in the last year since the first order. They have not been set, or they've not happened by pursuant to the emergency order we're under now. Now that we're having jury trials, what do you think is happening to the speedy trial motions? Since we're still under an emergency, but we are allowed to have jury trials. When does this go into effect? That's what I'm saying. When there's no statewide emergency?
Right. It's after.
And that's going to be another year,
Yeah, we don't know.
but is another year a safe assumption? I have no idea. I'm trying to be practical here about when does this
Sure.
start?
And you're spot on. We don't know, break the mic. We don't know how long the public health emergency is going to last, because we know that with the vaccine rollout in particular, that state of emergency may stay in place. I'll tell you this, when we considered the bill in the Senate, we added that overall sunset. In some ways, it doesn't make sense to read it all together as you're starting to look at why sunset that date. We went through, a lot of us in the Senate looking at this, we kept thinking, okay, we could do this a little bit better. We could do this instead. We can require this certification. Some people didn't like the idea of the chief judge having this much power. Some people didn't like the idea of the chief judge, Supreme Court having the oversight like this, or the chief justice. But the more we looked at it, we couldn't come up with a better way of doing it. We realized we probably need this flexibility. And the other concern we had was the lack of data and knowing what's exactly going to happen. How many cases are going to be pending? How long is the public health emergency going to last, as we've said? And so we built that sunset in as a legislative check, knowing that that's going to require us to come back and bring this bill again. And then we can learn from the last 2 years as to what's happened. And so while the sunset seems somewhat inconsistent with overall the bill, that was a way we could come back and look at this again and make sure we got it right and see if we should do it differently, see if we should extend this. As you know, that's the biggest thing a sunset does, is makes us come back in and look at something again. That
I
was our
like
thought
the
process.
sunset. I like the sunset. I would proceed for, obviously right now, I'd rather keep it, but as if I file a motion for a speedy trial today, is it effective even though we have a emergency order, since we are allowing jury trials? Are we still not going to have, he's still not going to, under today, we're,
Our judges can speak to
The present
Situation.
before you do that, need somebody on microphone. Oh, yes, sorry. Yeah, thank you. I apologize. What's the number you made? So in answer to your question, Representative Oliver, presently the statewide judicial emergency order stays the effectiveness. I'm sorry. I apologize. The effect of the demand for speedy trial is stayed pursuant to the statewide judicial emergency order.
some judges are going to have criminal trials.
Correct. Yes. And so as I understand the basis for this bill is twofold. First is to allow for the orderly administration of justice when the statewide judicial emergency order is lifted, so that presently, instead of having a rush to the courthouse with the demands for speedy trial and cases that are brand new being tried before cases that are 3 or 4 years old, we can do as this legislation would require, which is to come up with a plan for how we will address those cases in age order. So we'll start with the cases that were pending before COVID, before the statewide judicial emergency order, and work through the ones that are pending now and have come to be pending during the pandemic. And so the other is to allow us the flexibility to see what happens when this is lifted, because as you've alluded to, we really don't know what's going to happen. We've got some operating assumptions. In Fulton County, for instance, we've kind of come up with an operating assumption that it's going to take us 3 years from whenever we can expand our operations to get through the backlog. And we're planning that from a financial standpoint. What are we going to need to do to be able to stand up?
Are you going to have jury trials on speedy trials now?
We're going to we've got a jury trial calendar planned for next week. So we were anticipating, based on what the Chief Justice had told us, that our authority would be turned on. So we're calling a jury trial calendar on Monday. We've got another one the week after that, and another one 2 weeks after that.
So if a particular chief judge, hypothetically, obviously not y'all, decide, well, I'm just not going to have any jury trials for another year, I'm just going to, then his certification would have to account for the fact that he or she hadn't done anything for a year when others have chosen.
Exactly.
So that would be a little bit of a check perhaps on.
In addition to what I would presume whether it's Chief Justice Melton or whoever comes after him as Chief Justice is going to have the ability under this legislation to strike that down. And I can't imagine that not having done anything to keep yourself out of that hole won't be a consideration of that as well. I hope I answered your question.
Thank you. It's very helpful.
Well, thank you, Mr. Chairman, and I want to thank
Jamero and Judge Brasher for being here today and their helpful testimony. I think the need for legislation along these lines is very apparent with the current circumstances that we have, and really codifying how we're going to address this issue so that we can ensure that those awaiting trial are able to pursue their speedy trial demands after the emergency. And we know when that will be, I think is really important. I just, when we really get into, and I am also interested in any further feedback the judges that are here with us have to give, but when we get into the timeline that we're discussing here, and I'm wondering about the need for lines 124 to 125, that's subsection 10, about the total amount of time being the double the length of the preceding judicial emergency. And just what I'm envisioning is we have a lot of criteria that we're putting on this period already. It can be a maximum of 8 months, must end at the end of the term, the final day of the term. And then we have the sunset on top of that. And what do we do if the end of the term is not going to, or would fall outside of the double length of the most recent judicial emergency? And then I think this through, what if we're looking at an order and we think that we're, the judicial emergency, statewide emergency ending, we're getting back to normal, and then another one's issued that maybe doesn't have the same length of the first. What do we do under those circumstances? So I guess my question is, with the sunset that was added in the Senate, does the Judicial Council still believe that lines 124 and 125 are necessary? And if so, why?
I would say that it was our version of a sunset. So we understood that there was a need for some limits on this authority. And so, but I think that this is, we do favor this because that is ultimately what we came up with as something that is based on operational criteria as opposed to a date on a calendar. So I would say that we do favor having keeping it in.
And just to clarify a point that you made earlier to the chairman's question. So hypothetically, an order could be issued just prior to July of 2023, and it could be for a period of 8 months. At the end, I think of Gwinnett, where I live, a term begins in December. There's a December term. So it could be really through the end of, toward the end of, it could be until December, early December of 23, that the order could be in place, correct? If it was issued prior to July, or prior to June 30th.
Whatever the order is issued, if it's issued on June 30th, the order will last only eight more months than that. That would be a hard stop. You can't do multiple orders because you have your last order and then the statute's gone and you can't use it again.
Yeah, I agree. I was just making sure
Sure.
that was your review of how it read. Thank you.
Thank you, Mr. Chairman. I think the bill makes a lot of practical sense as far as the overall general concept. I wanted to make sure I was understanding the language right, that basically the chief judge or a majority of the judges within the court are the ones that can trigger this.
That's correct.
Is there any check outside of that county?
The Chief Justice. He could completely vacate the order.
Well, he could vacate it, but he would have to act. It's not
would.
that they have to send it and he has to say yes or no.
No, yeah, they're issuing it, and there is the provision in here that requires notice. It's the same provision that we have for judicial emergencies. So every time somebody issues one of these, the Chief Justice would be made aware automatically. It's a notice requirement. So he would be able to scrutinize. He or she would be able to scrutinize each one as they're issued each time.
Thank you.
You're welcome. Oh yeah, we're almost there. So as I alluded to just a moment ago, there is a notification provision, 126, line 126 through 129. It's the same notice requirement as we have for current judicial emergencies based on Code Section 38363. And so we were using the same mechanism, tried and true. Line 130, this is where the Chief Justice has his or her accountability measure. And under the authority of the Chief Justice in his or her discretion, he or she can reinstate the speedy trial requirements that are granted relief. And if he or she does so, the Chief Judge is no longer able to issue further relief unless the Chief Justice authorizes that. And finally, line 137 and 138, we're making it clear that this is statutory speedy trial. This is not constitutional speedy trial. Constitutional speedy trial is still very much alive, and the state shall still have the obligation to meet that requirement. And finally, the sunset that was added in the Senate till June 30, 2023, no order granting relief shall be issued after that date. All right.
Any other questions from the committee? Yes, Commissioner Inns. All right. And since we have our judges here, if Judge Amaro, if you want to introduce yourself, I think Judge Brasher's already.
Sure. My name is Brian Amaro, and I'm the president of the Council of Superior Court Judges. Thank you for the opportunity to be here with all of you today. I think that the questions that we've heard so far have really illustrated to us that you're deeply considering the importance of the bill and all of the aspects of the language of the bill. And so it's gratifying for me to participate in the process and to see that from our colleagues, see that from you. I also want to say that the Council of Superior Court Judges strongly supports this legislation in its current form. I have never seen a piece of legislation that has been so carefully vetted. I've never seen a piece of legislation that's affected the judiciary in my 15-year career where all of the parties have compromised and considered each other's point of view and collegially worked through this set of issues. Everyone understands that we have a preference for adjudicating cases on the merits. And there's certainly no appetite for broad dismissal of cases by operation of law. Because we all know, many of us who are attorneys in this room know what it would mean to have to explain to a victim of a crime why this has happened. And I just want to point out a couple of things really quickly in response to some of the questions. First is from Representative Oliver. He talked about a chief judge who has made a decision not to be diligent over the course of a full year. Well, I can just imagine how Justice Namias, if he succeeds, Chief Justice Melton would view that certification. And what's interesting about this fail-safe provision is it's an instant black eye. This is vacating the order without an order and taking away your ability to issue another one until he says so. Can you imagine being a chief judge who's had the Chief Justice of the Supreme Court do that to your order? Can you imagine the impact politically? And so that really ties into I want to call him Stan because I've known him for so long as a judge, but as Representative Gunter was talking about the other relevant factors on line 76, justifying ongoing relief from statutory speedy trial requirements. If you're getting into the other relevant factors part of this analysis, you really better be careful, because that's going to be very carefully scrutinized by the Chief Justice. And I expect that the use of that section would be very much limited. This black eye that the Chief Justice can give us if we are not exercising our authority appropriately, is a real deterrent to misuse, to lack of diligence, to any overuse or abuse. This is something that constrains us. And it's something that I wanted you to hear from me that we take very seriously. We don't necessarily like this, but everybody's compromised as part of this process. And we feel that this is an area where we need to give a little too. And so if he wants to do this, he thinks he has the right grounds and reason that we haven't demonstrated sufficiently the need for this extension or tolling, then so be it, and we will accept that judgment. That really protects the public and protects everybody involved.
All right. Thank you, Judge Amaro. I'll call on the author. You have anything you want to add?
No, I think they covered it very, very well. And I appreciate you guys being patient with me. I was presenting in 3 places at once, as we all know how that is this time of year. But I appreciate all the work that went into this. And I always like to give credit where credit's due. My name's on this, but as you see, there was a lot of work behind the scenes leading up to this. And I appreciate all the parties coming together and crafting this. And I would encourage us to, if we can, consider that when we look at any changes we want to make to this bill.
Okay.
So, appreciate it.
We have a few more people that want to speak on the bill, so let me call them in and
Thank you.
let's see.
Thank you for your time.
All right, who should we? All right. If y'all would send Jill Travis in, I think, oh, she's online?
Am I good sitting here?
Hey, good afternoon, Mr. Chairman. Can you hear me
Hang on.
okay?
Hang on, Jill.
Okay.
Do you know how to turn her on? Yeah. Do you know how to turn her on?
Yeah, I think so.
I've got computer audio up.
Just let me know when you're ready for me.
There you are, Ms. Travis, you're good.
Good afternoon, Mr. Chairman and members of the Judiciary Committee. It's my honor to be with you today. I'm the Executive Director and a Policy Advocate for the Georgia Association of Criminal Defense Lawyers, coming to you from home with a voice of Otis, my wild child behind me, and hopefully I don't have to excuse him for bad behavior. Apologies. Trying to limit our time down at the Capitol as much as possible. As has been mentioned previously, this process of creating a way to deal with an exhaust valve, for lack of a better way to say it, of the amount of backlog of cases that has been created has been a work in progress. The Judicial Council began discussions on this matter in the fall. We were engaged in those discussions, and there were certainly a number of points that we raised, as was mentioned by Darren during his presentation, so I won't repeat that. I will tell you that another point that we did raise during the discussion was that we thought it was important to actually look at how many demands for speedy trial are filed, because this is not just about trying cases. You know, we all know that it's going to take a long time to dig out from this hole. There's going to be, because there's people that are on bond, there's people in custody, but the number of people that are speedy trial demands, that's, to me, to Gactyl, that's the #1 issue, is if you need a release valve, it should be singularly focused on what are we releasing from. We shouldn't be releasing the ability to file a statutory speedy trial demand because there's not enough judges, there's not enough prosecutors. It should be really focused on what are our speedy trials, because that's what you're stopping. You're stopping the ability to go forward on speedy trial demands. The language that's in the bill is, so the number of speedy trial demands wasn't in the initial draft, so it's now been included. It was included as filed, and we do appreciate that. We would suggest that a better language having to do with calculating speedy trial demands should be a correlation of how many speedy trials were in effect, say March 12th of 2020, so before the judicial emergency, or how many speedy trial demands were in effect during the first iteration of a post-trial, post-judicial emergency order. So if, let's just say on March the 12th last year, there were 50 demands for speedy trial. And when the floodgates open, there's 51. Well, life hasn't changed a whole lot. But if there's 151, life has changed a lot. And the jurisdiction should be looking for relief. Just because, and to me, that would be a perfect example of why a jurisdiction should be able to grant an order under this kind of code section. But so I would suggest that you should look at those two factors, and then that it should be compared to what's going on right now. And the language within 1 month of the date of the certification probably works fine, but it's not just pending, it should be pending when. You've raised a number of questions, really good points, and I'm going to try to, I'm not necessarily going to go in order of the bill, but I'm going to try to answer some of your questions. One of the very first things that, Mr. Chairman, you mentioned was, when does this take effect? When does this start? One of the things that I would recommend is the language that we had suggested is using something like the judicial emergency has expired. At some point in each of Justice Melton's orders, there's an expiration date, right? So when Justice Melton's order expires, that's when we should be going forward. The issue of, we want to be clear, what we want, we think the legislative intent is to be clear that we can't just evaporate statutory speedy trial demands, but we can provide some relief when this issue arises from the preceding judicial emergency. And that needs to be tied, the arising to language is found on line 56, but it's not in lines 50 to 54. You'll see in lines 50 to 54, it's just granting statutory speedy trial requirements following a judicial emergency order. It's not necessarily because of the judicial emergency order. Which brings us into the factors, and I think you raised an excellent point of any one of the following factors. That's on lines 58 to 59. That's one of the problems. It's any one factor can be enough. So would ask the committee to consider changing the or to an and at line 75. We have true concerns about lines 76 to 77 as a catch-all, because this really should be aimed at speedy trials. We have concerns about lines 71 to 73, just because I've sat through enough budgetary hearings where judges and prosecutors and public defenders and everybody in GBI, everybody needs more money, law enforcement needs more money. And just because there's staffing issues, to take away this very valued right is of great concern. I mean, to Judge Amero's point, to explaining to crime victims what this could mean if somebody was let out because of really a technicality, is I think what most people would say. Please consider, what about explaining to the innocent defendant who's been in custody for 2.5 years waiting to get a trial? What about that person? They have rights too, and that should be something that comes into consideration when we're talking about suspending the right to file a demand for speedy trial. Just to give you a little bit more background on the sunset date of June 30th in 2023, it may sound like it came from thin air. It actually was tied, Mr. Chairman, I know you're familiar with House Bill 555, which was the bill that would have allowed defendants to ask for a bench trial without the consent of the prosecuting attorney. The idea from that bill was to allow a period of time where more cases could be resolved without the use of a jury. The time period for that to expire was June 30th, 2023. And so that same date was used on line 139. It does sort of conflate. I agree with the point that was made. I'm sorry, I don't remember who made it, but the point of having lines 124 and 125 when you have lines 139 and 140, it seems to me that it causes more confusion than solves an issue. I think another issue that I'm just coming around to trying to put my head around, and because this is subcommittee, I'm just going to brainstorm a little bit with y'all. And that is, and it was mentioned in the Senate Judiciary Committee, Chairman, Senator Calzert brought it up, is what about bond for these people? What about getting, if we're not going to try the case, what about setting a bond for these folks? The Oregon legislature struggled with the same issue. They took care of it last year, last spring. And there in Oregon, there's a requirement that anybody that's in custody has to have a trial within 180 days. It's much stricter than our rules. But what they did was they extended the time during COVID, even, during the judicial emergency and afterwards, for another 180 days. And then they separated out whether the person was charged with a violent felony, and they gave a little bit of extra time, but they required the court to consider bond for the accused. And also if somebody was charged, they call it a person crime. And I think we can all, I don't know, I didn't look at their definition of person crime, but I think we in this room know the difference between a person crime and a property crime. If it was a person crime, they extended the period instead of 180 days to 240 days. And then they gave specific criteria for the judge to look at in determining whether a release of the defendant should be authorized. And by clear and convincing evidence that the person would be a substantial and specific danger of physical injury or sexual victimization. And the reason I'm bringing this up is this is going to be a long period of time, potentially a very long period of time, where people are remaining in custody that don't have a way to get out. And with these factors being as broad as they are, it is disconcerting to us to have this in place. That is not to say that we don't agree that something has to be in place. And that is not to diminish our appreciation for the Judicial Council and those involved for including some of our suggestions. We very much appreciate their inclusion of some of our ideas, but we hope it's because they thought they were good ideas and not just because they were trying to appease us.
All right, Ms. Travis, let me stop you right there. Chairman Administration.
Thank you, Ms. Travis, and appreciate you bringing up bond. I'm not aware that issue is being directly targeted by any legislation this year. Are you?
No, I'm not aware of it, not specifically. And as I said, Senator Calzert brought it up, and it wasn't until I found this Oregon legislation that I could see a way that could be connected.
Well, certainly once the judicial emergency is lifted and grand juries are resuming, once the judicial emergency is lifted, any pre-indictment case without a bond will have to get a bond by operation of existing law. So in part, what you're describing would have to happen for the pre-indictment cases immediately when the judicial emergency is lifted. So that may be in part addressing the concern that you're raising. Is that fair?
I think that's fair, Mr. Chairman. It is fair. It's the difficulty is those folks that are either have been there longer than that, or it's this zone of probably the last year of cases.
And finally, about the factors, I understand your position on a reference point for, say, the number of demands that have been filed. As what is that compared to? But ultimately, this would be you're not asking for anything more than the chief judge or a majority of the judges would just be considering that number, and that consideration would be part of the order within the circuit. In other words, there's no one to approve that is truly in fact a disproportionate increase in the number of demands, or that there is no one's giving clearance to or agreeing, having to provide agreement with, that there is a spike in demands that are filed. You're just saying that that should be a reference point should be provided in the factor. Is that correct?
That's correct, Mr. Chairman.
All right, thank you.
All right, Ms. Travis, anything else you want to tell us?
I don't think that I have anything else to add to my presentation. I'm happy to answer any questions. I do appreciate your time. It's nice to be with you virtually today, and I wish you all the best. If we can help it at all with any language suggestions or changes, we'd be happy to do so.
All right, thank you. I have a question from Chairman Oliver.
I'm puzzling over your reference to numbers, specific numbers. I'm looking at line 66. That gives a number of speedy trial demands pending within 1 month. But I guess what you're thinking about is how many were already pending before and after. And so you're not asking for numerosity on little I and double I, 60 and 63 about substantial criminal cases. You're really only looking at the numerosity in terms of the speedy trial.
That's correct.
Thank you.
That's Division 3, Madam.
Thank
And yes, it's because if one was pending before and now we've got 6 months of jury trials, that shouldn't be enough to be a factor. But I think you're following me.
Thank you.
Thank you.
All right, any other questions? All right, thank you, Ms. Travis.
Good afternoon, everyone.
All right. Let's call in Deborah Nesbitt.
Mr. Chairman, can I ask,
Yes, sir.
we're having ATL transit board elections that I'm running back and forth.
Yes, sir.
What is do we still have a number of?
Just Ms. Nesbitt and Pete Scandalakis. Those are the last two I had.
Work on it. You have to go. You can connect.
Yeah.
It's a little bit of a delay in the hall.
Oh.
Thank you, Mr. Chairman and members of the committee. I'm Deborah Nesbitt, and I'm here representing the Association of County Commissioners. And we are very much in support of this bill. We just feel like there's going to be a crush of cases that we're just not going to be able to handle. We're not going to have staff or resources. So I'm just here to offer our full support.
Okay. All right. Any questions for Ms. Nesbitt? All right, Ms. Nesbitt, thank you. And if you
Who
tell
you ready for?
Pete.
I gotta get close to him. He doesn't hear well.
You poking fun at me, Mr.
It
Chairman?
wasn't me. It wasn't me.
Who was it? Oh, it was Deborah. Okay. Thank you very much.
That's okay. So.
Well, thank you very much. It's always a pleasure to be here. I represent the prosecutors of the state of Georgia, the DA's Association in this case, and the Solicitor Generals. Typically, PAC does not get involved in these type of things, but just wanted you to know that prosecutors do support this bill. I will tell you just briefly, I did a survey. The Prosecuting Attorneys Council did a survey at the end of December to see how many undrawn cases we had pending in DA's offices. And when I say undrawn cases, that is cases that are not already on the calendar as either an accusation or an indictment. These are cases that are sitting in a DA's office ready for a grand jury to hear, or ready to be filed by accusation, or ready to be reviewed to go to a pretrial or to be dismissed. And at that time, of the 49 judicial circuits, I got 41 responses of 42, and we had 60,000 pending undrawn cases at that time. Particularly in the metro area, as you well know, that would be a significant amount just by themselves, but throughout the state. So we do need this. This is an extraordinary bill. There's no doubt about it, but this is an extraordinary time. And I think the chief judge of every circuit will have a plan where we can move cases efficiently and effectively and be able to deal with this situation. So that's it. And if y'all have any questions, I'll be glad to answer them.
Do you have an idea of how many cases have been drawn that are pending now?
I do not. I was asked that information, but I did not get it. And when you say have been drawn, are you talking about we're ready for indictment?
Have already been indicted that are in the
I do-
system.
That's the one thing, Chairman Gunter, I could not find out how many cases that are on a trial calendar now as we speak, because as y'all well knows, you still had cases that were on the trial calendar when we had to shut the courts down in March last year. So that I don't know, but I will try to get that number for you.
Okay. And any idea of how many pending speedy trial demands there are?
No, sir, I do not
Do you
know
have a
that.
way of knowing that through
I would ha-
Tracker?
I would not be able to do that. I could do that to a certain extent through Tracker on the DAs that enter that information through Tracker. However, I would not be able to do that. Some of the bigger metro areas do not use the Tracker case management system, and we'd have to do it by circuit. So that would be a little bit more difficult to find.
Okay. All right. Thank you. I appreciate that. Are there any other questions for Mr. Scandalakis? Anybody online? All right. Thank you, Pete.
Thank you, sir.
All right. I think that's all of our witnesses, and we're not going to take a vote on it today. Is there any further discussion of it before we break, though? From anybody? Okay. And you know when the next?
We'll hear this in full Monday at 1:30.
Okay, so we'll just take it out of here and just send it on up.
Yeah.
Okay. All right.
That's correct.
All right. Yep, we're adjourned.